Judge, since we have a little bit of a time crunch.
We do have to do that. He's ready to go.
Okay.
Okay, great, thank you.
And I know the prosecutors aren't here, but
Get my hand in there.
we get them down here, so we can make a brief argument. Just discussion, realistically, it's simple stuff, like the font is really small. They came out tiny on this one for some reason.
What?
Yeah, look at the one you handed us yesterday was perfect. And then look how it comes out now.
All right, let me look. There's something weird with that.
The other thing, Judge, is just real simple. We're gonna ask that these be separate pages instead of all bunched up like.
Oh, no, that's something is with your printer.
Okay.
Let me see.
Okay, please. Yeah, something.
Let me see. Oh, yeah, there's something wrong with your printer.
Okay, came out okay?
Mm-hmm.
These are two gentlemen that had their name. They brought the wrong person yesterday.
Okay.
And I did talk to Yaya.
All right.
No worries, girl. Please. Why is it hot in here?
No, it's not hot.
It's very hot. I'm hot.
Yeah. Something's wrong with your printer.
Oh, good, okay. So then are the counts on different pages with regard to the lessers?
I'll print. Are you gonna ask for the lessers
Yes,
before I
we
print
are.
this out?
Yes, we are.
Okay.
You always dress so sharp.
Really?
There's like maybe like only like 3 attorneys I know. They're always like.
Oh, well, thank you, thank you.
And yes, they are on different pages.
Perfect. Then we got nothing.
Okay.
Ready to go.
Okay.
Where'd you get this? It's like custom.
Nice. Yeah.
Yes, sir.
What I just printed, can you make 6 copies? Thank you.
Thank you.
You're welcome.
That's all right. Yes. Yeah. And Judge, we did bring Ezekiel. He's the one in the bottom.
Okay. Who's his attorney?
Richard Garcia.
Oh, Richard Garcia should be here.
What I was informed is that he's not very stable, but he's here today.
Okay.
I remember for 2 years ago.
Or 2:30 in the morning.
Oh, that's early.
We got so many of them to do, especially if they need to dress out.
And then they get breakfast that early too. They're
Ah,
the first ones to have breakfast.
yeah. I do understand though, because they do have to,
Like
Dress.
time.
mhm.
It's a lot of cool, man, a lot of people.
Are you Paul Diaz? All right, you need to take a seat in the box. And Miss, if you want to call his attorney, because we're going to start up with this trial at 9:30. Well, I mean, let him know that we're starting up at 9:30.
And then can we touch you?
Yeah.
Why? I do that, but I do. That was at work. How was that work?
What happens is,
I don't know, what do I feel like right now?
what happens is that when you don't show up, it turns into a warrant.
Oh,
So
so-
yesterday was the day was,
Oh, okay.
you were
Yeah, you know,
supposed,
yeah.
that's why that's why judge asked, was it your girlfriend or your wife
I'm
to,
wife.
to call your attorney?
Yeah, yeah, that was weird. You know, my attorney called me yesterday at like 3 o'clock. Tell me, oh, 2 o'clock. Tell me, you have court today. I was like.
So that's why. Okay.
Interesting. Still gotta put these on. Yeah. Whatever. Yeah.
No, he's down there, we have him down there.
Oh,
We don't need him. He was not part of our. Or any.
and if you put these two on their side,
Thank you.
and if you could give, oh, and there's one for your client, and I forgot, he's Spanish. And if you could give that to the court reporter.
Sure.
Yes.
Thank you.
We had to change anything else. I need to say it. Well, this.
Another one?
Not here, not here. Jose Ángel Cervantes? That's you?
And Deputy Laura, could you check to see if all the jurors are here? Because if they're here, then they'll need to go back, because we're gonna start, and when I say go back, just in the holding cells back there, because we're gonna start exactly at 9:30. You're welcome.
The only other issue we're gonna bring up once the prosecutors get here is we're gonna request that a motion to eliminate regarding the punishment range for the lesser included offense, since that is not something that the jury will have any um, power over. We're requesting that they not be allowed to speak about the punishment range
All right,
or the level of offense.
Not yet, Judge.
all right,
They
thank you.
still have 15 minutes.
No, I was just saying that if
Oh.
they're already here, then we can put them in the back, because I don't want there to be this gap in time. And we can just bring them out right away. And is their client here?
Yes, we have him back.
Oh, can you guys bring him out so that they can talk to him about the jury charge? Does he only speak Spanish?
I believe so.
All right, Megan, do you, hello. He's not your client, but do you mind letting him know that the only thing the officer just gave him was his indictment and nothing else? Thank you.
Cervantes.
And if you'll let him know that that's just to tell him what he's being accused of.
Good morning.
Yes. Yes.
Ask him what is his full name? All right, who is Mr. Cervantes' attorney?
Michael
Devion.
He was in
Oh,
trial.
it's Michael DeLeon.
He understands English. It's this one who doesn't understand it. He was the one that
No,
was
he
here.
said he doesn't
Oh,
understand.
okay.
All right, so. And if you'll let him know that Michael DeLeon is in a jury trial, that's why he's not here. And what date did we give him? Let me see. And tell him he's gonna come back on February 27th.
And the other gentleman doesn't belong to us, Judge.
Who is the other gentleman?
The one that was in his place yesterday.
Ah, okay. Is that him there?
Yes. Also in red.
All right, what court does he belong to?
Do you know what he does? Mhm. I don't have a case number for him.
And I'm sorry, Megan, one last thing, because I want to be sure that's the right guy. Could you ask him what his SID number is?
27. ¿Cuál es tu número de SID de identificación, señor?
Bonnie Foster has a status conference
115.
today.
Yes, that's the correct person then. All right, thank you. And then you, sir. You're also Mr. Cervantes. You're actually not in this court. Deputy Laura, can you let him know that he's in the 227th?
He has a court today.
And you have court today, so we're gonna send you to the 227th. We have two, Jose Cervantes.
Oh, this one's Bonnie Foster.
Bonifacio.
So if you could let the 227th know he's here.
Yeah.
And that we're sending him there.
You're done with that?
Yes.
accidents.
Come on. You want this? Both of you.
Los dos. No, we have to get one to come in to our court, the wrong one that curved the paperwork. So we have.
Oh, deputy,
25 Cervantes,
you can go ahead and have them
court
wait in the back. If y'all are able to let them wait in the back, is that possible?
So he's here, but he's being moved over to.
All right, we'll bring you all back once we have a break.
Yeah, so when he got people on, he is set for service conference today at noon. So, we have him here, we're putting him back in the holding for the, you're gonna need to come get him. All right, thank you. Okay, just, they'll come and get him.
Separate holding cell.
All right, thank you.
You have your cell phone with you? We have to take ours. But they're put them in separate ones. Thank you. We accidentally, well, not accidentally, yesterday we found the, an inmate from the jail that it belongs to your court, but he had a hearing or something in the court today. Cervantes, Bonifacio,
Bonifacio.
no, he's a male. Cervantes. Bonifacio, B, would be more. Okay, so on the ticket, I scratched off 187, I put 227 on there, and I highlighted it. So he'll be a 1.5. All right.
Yeah, I looked, my first.
Well, it's not 9:30 yet.
Almost 9.
Oh,
You told all of us.
well, I guess what? Your charge is going to be the charge.
Thank you. Hey, good morning.
All right, both sides are going to have 15 minutes for closing. And we're going to go on the record. Court is calling 2023 CR 4709 State versus Edgar Aguilar. Can I have parties announced for the record for the state,
Yeah, we have Jason Garahan for the state,
for the defense?
Megan Enriquez and John Combs for the, for Edgar Aguilar.
And are you Mr. Aguilar?
I'm sorry, Your Honor.
Are you Mr. Aguilar?
Yes.
Oh, thank you. And we have the interpreter here. Just out of abundance of caution, I'm going to swear her in again today. Could you raise your right hand? Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right. And if you could state your name for the record.
Mariana.
All right, thank you.
Should I give my part from this one now? Yeah.
We are asking for the less. We are asking for the less.
Okay, I'm gonna call down.
Then Megan's gonna shank you.
Maybe we'll be the person that did that.
Okay. All right, and everyone, I placed on your desk the jury charge. The defense is asking for lessers. So are there any objections to the lessers, state?
No, Your Honor.
Thank you, Judge. And the only other thing that we would like to address is that we would request that the prosecutors be,
Oh, please remain seated. Yeah.
it's not right to sit
I
and talk to
know.
a judge. It doesn't feel right. We're requesting that the prosecutors not be allowed to reference a punishment range or degree of offense or anything with regard to the lesser or even the current charge.
All right, state defense is requesting that you not tell the jury the range of punishment for either of the offenses.
Well, Judge, I mean, I think that would be disingenuous to the jury because they should be allowed to know what the range is. They know what the range is for the assault deadly weapon. We'd be asking that, one, it says it's a lesser included, hence meaning that it's lesser than the ag assault deadly weapon. To not address that the possible range of punishment would be leaving a false impression to the jury.
Judge, as you know, the jury, we did not address punishment with the jury, even during jury selection, the punishment range or anything like that. The second thing is punishment ranges are irrelevant during the guilt innocence portion of a trial. They're never to be considered even. So I'm not sure legally what leg the state would have to stand on to say that they're able to discuss the punishment ranges of either offense.
Right. So what I can tell the parties is my understanding of the law, and if I'm incorrect, do not hesitate to let me know, is that during the first phase of a jury trial, the jury's only duty is to determine whether a defendant is guilty or not guilty and nothing else. They're not to consider what the punishment range is. And even if the defendant were coming to the court, we're going to the jury for punishment, this jury still would not be allowed to be told in closing arguments the range of punishment. However, the state is allowed to argue that it is a lesser included offense because it clearly states in the charge of the court that it is lesser included offense, but they're not allowed to talk about the range of punishment.
Thank you, Judge. And also just to be clear, they're not allowed to say this is just a misdemeanor or something like that, the lesser.
No, they're allowed to say that it is a lesser included offense. Now, if they want to explain what a lesser included offense is, then they can explain what a lesser included offense is. And when I say that, they are still not allowed to say that this is the range of punishment, that are they allowed to say it's a misdemeanor? I don't see why they would not be allowed to say that it's a misdemeanor because in the jury charge, it clearly states that he's charged with the felony offense of aggravated assault with a deadly weapon. And if anyone believes that I'm incorrect in stating that, please let me know.
So Your Honor, that so what he's charged with is a second degree felony. There are other felony level offenses that are under secondary offense, and they wouldn't know that if it was a third degree or state jail, it could still be a felony or there are
Say it was an aggravated robbery trial and the lesser was robbery. You wouldn't allow them to discuss the ranges of punishment or anything like that, or even a misdemeanor theft is a lesser of an aggravated robbery in theory.
Mhm.
So they wouldn't be allowed to discuss that, those sorts of things in that regard. So I would again request that in this circumstance, they not be allowed to address either punishment range or that one is a misdemeanor, one is a felony or anything like that.
All right, state,
Your Honor, the position of the state is that one, as the court has mentioned before, it is a misdemeanor. And again, leaving a false impression to the jury at this point, a felony down to a misdemeanor would leave a false impression with the jury, that a lesser charge of what it is. And in this particular category, it is a misdemeanor. We're not mentioning that it's a class C, a class B, or a class A, but it fits into the category of a misdemeanor.
Judge, I think when you said earlier that to allow them to discuss that it's a lesser, we're 100% fine with that. Obviously, we're requesting a lesser included offense, but any further discussion with regard to punishment range, misdemeanor versus felony, anything like that, I think would be improper.
all right, any other argument?
No, Your Honor.
All right, the court is going to allow the state to state that the assault is a lesser included offense and that it is the lesser included offense of misdemeanor assault. And that is all. Now, if my understanding, the jury is not here present, if someone has some case law where the state should not be allowed to mention that it's a lesser included offense and it's a misdemeanor, I will of course entertain that.
pull up the full text of it though. I might have just found it. Hold on. No.
What I can tell everyone, all of the case law I read, it stated that a prosecutor can reference that it's a lesser included offense as a misdemeanor, but not make any explicit statement regarding the range of punishment assigned to felonies and misdemeanors. So the state can argue, this is a lesser included offense, it's a misdemeanor. That's it. That's it. Legally, that's all that can be argued. All right, are parties ready?
Yes, Judge.
Yes, sir.
Yes, Judge.
All right, we're ready.
Okay.
Split up your time, or you're gonna withhold it all for this? It's like,
Probably gonna split it.
okay.
The first one was. Wow.
They are in spot.
Oh.
Apparently he doesn't believe in Megan.
Exactly right.
He feels like he has to do some of the work. That's your boss.
Hey,
okay.
this bald guy's got to stick it up. I know how you feel about.
I'm letting her
No,
do it all.
no,
Trust
no,
me.
no, no.
Yeah. Um, You don't need, you don't need, you don't need to be that angry. Trust me, you definitely don't need to be that.
Yes.
All right, for the jury?
All right, everyone, please be seated. All right, ladies and gentlemen, I'm going to read to you what is entitled the charge of the court. It's the jury charge. You do not have to memorize it. You will be given the original when you begin your deliberations. Charge of the court. Members of the jury, the defendant Edgar Hernandez Aguilar stands charged in counts 1, 2, and 3 of the indictment with the offenses of aggravated assault with a deadly weapon alleged to have been committed on or about the 16th day of March 2023 in Bexar County, Texas. To these offenses, the defendant has pleaded not guilty. 1, our law provides that a person commits the offense of assault if the person intentionally or knowingly threatens another with imminent bodily injury. A person commits the offense of aggravated assault with a deadly weapon if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the assault. 2, deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition. Just one moment. Excuse me, could you hold this to the interpreter? They'll probably make it easier for her to follow along.
Thank you, Judge.
You're welcome. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. 3, a person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. 4, count 1. Now, if you find from the evidence beyond a reasonable doubt that on or about the 16th day of March 2023 in Bexar County, Texas, the defendant, Edgar Hernandez Aguilar, did use or exhibit a deadly weapon, namely a motor vehicle, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and Edgar Hernandez Aguilar did intentionally or knowingly threaten imminent bodily injury to Fatima Camacho by Edgar Hernandez Aguilar driving said motor vehicle into a vehicle occupied by Fatima Camacho, then you will find the defendant, Edgar Hernandez Aguilar, guilty of the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment, and do not consider the lesser included offense in paragraph 5, but instead proceed to paragraph 6. If you do not so find from beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Edgar Hernandez Aguilar, not guilty of the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment, and proceed to paragraph 5 to next consider whether the defendant is guilty or not guilty of the lesser included offense of assault under count 1. 5, count 1, lesser included offense of assault. Now, if you find from the evidence beyond a reasonable doubt that on or about the 16th day of March 2023 in Bexar County, Texas, the defendant, Edgar Hernandez Aguilar, did intentionally or knowingly threaten imminent bodily injury to Fatima Camacho by Edgar Hernandez Aguilar driving his motor vehicle into a vehicle occupied by Fatima Camacho, then you will find the defendant, Edgar Hernandez Aguilar, guilty of the lesser included offense of assault under count 1. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Edgar Hernandez Aguilar, not guilty of the lesser included offense of assault under count 1. 6, count 2. Now, if you find from the evidence beyond a reasonable doubt that on or about the 16th day of March 2023 in Bexar County, Texas, the defendant, Edgar Hernandez Aguilar, did use or exhibit a deadly weapon, namely a motor vehicle that in the manner of its use or intended use was capable of causing death or serious bodily injury, and Edgar Hernandez Aguilar did intentionally or knowingly threaten imminent bodily injury to Raquel Ildefonso Ortega by Edgar Hernandez Aguilar driving said motor vehicle into a vehicle occupied by Raquel Ildefonso Ortega, then you will find the defendant, Edgar Hernandez Aguilar, guilty of the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment. Do not consider the lesser included offense in paragraph 7, but instead proceed to paragraph 8. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Edgar Hernandez Aguilar, not guilty of the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment, and proceed to paragraph 7 to next consider whether the defendant is guilty or not guilty of the less included offense of assault under count 2. 7, count 2, lesser included offense of assault. Now, if you find from the evidence beyond a reasonable doubt that on or about the 16th day of March 2023 in Bexar County, Texas, the defendant, Edgar Hernandez Aguilar, did intentionally or knowingly threaten imminent bodily injury to Raquel Ildefonso Ortega by Edgar Hernandez Aguilar driving his motor vehicle into a vehicle occupied by Raquel Ildefonso Ortega, then you will find the defendant, Edgar Hernandez Aguilar, guilty of the lesser included offense of assault under count 2. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Edgar Hernandez Aguilar, not guilty of the lesser included offense of assault under count 2. 8, count 3. Now, if you find from the evidence beyond a reasonable doubt that on or about the 16th day of March 2023 in Bexar County, Texas, the defendant, Edgar Hernandez Aguilar did use or exhibit a deadly weapon, namely a motor vehicle, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and Edgar Hernandez Aguilar did intentionally or knowingly threaten imminent bodily injury to Brittany Camacho by Edgar Hernandez Aguilar driving said motor vehicle into a vehicle occupied by Brittany Camacho, then you will find the defendant, Edgar Hernandez Aguilar, guilty of the offense of aggravated assault with a deadly weapon as charged in count 3 of the indictment. Do not consider the lesser included offense in paragraph 9, but instead proceed to paragraph 10. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Edgar Hernandez Aguilar, not guilty of the offense of aggravated assault with a deadly weapon as charged in count 3 of the indictment, and proceed to paragraph 9 to next consider whether the defendant is guilty or not guilty of the lesser included offense of assault under count 3. 9, count 3, lesser included offense of assault. Now, if you find from the evidence beyond a reasonable doubt that on or about the 16th day of March 2023 in Bexar County, Texas, the defendant, Edgar Hernandez Aguilar, did intentionally or knowingly threaten imminent bodily injury to Brittany Camacho by Edgar Hernandez Aguilar driving his motor vehicle into a vehicle occupied by Brittany Camacho, then you will find the defendant, Edgar Hernandez Aguilar, guilty of the lesser included offense of assault under count 3. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Edgar Hernandez Aguilar, not guilty of the lesser included offense of assault under count 3. 10, you are instructed that if there is any evidence before you in this case regarding the defendants having committed offenses or acts of misconduct other than the offense alleged against him in the indictment in this case, you cannot consider said testimony for any purposes unless you find and believe beyond a reasonable doubt that the defendant committed such other offense or act of misconduct, and if any were committed, and even then you may only consider the same in determining the context of the offense committed, if any, in or to rebut a defensive theory, if applicable, and for no other purpose. To ensure that the jury, the court, and the parties are all receiving the same testimony, whenever a party or a witness does not speak English, the services of an interpreter are employed. You are instructed that you, as the juror, are to base your deliberations on the questions as they came from the attorneys in the English language, and the responses from the witness as they came from the interpreter in the English language. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purposes whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers intended by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can only send statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It's the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to your jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror was certified thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. But you are bound to receive the law from the court which is hearing given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, are you okay? Do you need a cough drop? Do you need any water? All right, thank you. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you in these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty or under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bexar County, Texas, and suitable forms are attached. State, are you ready to proceed?
Sorry, but maybe approach.
Yes. All right, State.
Thank you, Judge. Ladies and gentlemen, first of all, happy St. Valentine's Day. I know you probably wanted to be other places on your Valentine's Day, but we're here today. One, I do like to point out, I'm gonna speak to you first, and defense counsels will have a chance to speak with you, and then Megan will be summarizing the case at the end, and we'll speak to you last. So I'm just gonna talk to you a little bit about the charge. A lot of words, a lot of legalese in there. One thing I always ask and always mention is, don't leave your common sense at the front step of the courthouse. Common sense is what you can use to get through these, sometimes what I call legalese, or that's what it's been used in the past, but this is the charge of the court. This is my copy. I've written all over it and everything. You will get a copy of it back in the back. You don't have to memorize what the judge just said, so you will be able to read that again. But sometimes when you do read that, just read it, and sometimes read it out loud. It helps to understand it. I'm gonna go through it over briefly. It's several pages. It's 18 pages, 19, 20 or so pages, and 22 pages to be exact. And there's some forms at the back that is the verdict form that the judge mentioned. The first form is count 1, and then it has that lesser included, and then it has count 2, and then a lesser included, and then count 3, and a lesser included form for that. Now, the count 1 is aggravated assault with a deadly weapon. That deadly weapon being that motor vehicle. And if you find him guilty on count 1, you don't have to go to the lesser included. You don't have to find not guilty or guilty on that lesser included. You just go to the aggravated assault deadly weapon. That's what you say guilty, and you move on to the next count, which would be count 2, then count 3 for each individual victim in these cases. Now, addressing this lesser included of assault, it's a misdemeanor. And what that assault would be, that misdemeanor, is I walk over to Megan and I say, I don't have to say anything. I just put my hand up. That's an assault. That's what that is. You go back there with that's what you're saying that this man did to those 3 ladies on that highway. That's what you're saying. That's not okay. The deadly weapon is a motor vehicle. Her testimony about that motor vehicle, about how he reversed it and rammed it into the victim's car. Let's compare that deadly weapon, that motor vehicle, to a knife I have in my hand, and I approach somebody. I don't hit them. In and of itself, that knife is just there. But I'm directing it towards them, just like that motor vehicle. Directed towards those ladies in that vehicle. So if it's okay, go back there. And if you don't find that motor vehicle a deadly weapon in this particular case, say not guilty. Go back there and say not guilty. That's your oath. I understand that. I respect that. But you're saying it's okay. Use a deadly weapon, running people off the highway with this vehicle, and then proceededly, not once, not twice, at least 3 times, ram these ladies' vehicle when they're sitting just inches away in their vehicle. So I ask you to give your attention to defense counsel and their argument. They may be asking for not guilty, or that lesser included misdemeanor where you just raise your hand up and threaten. But I ask you to come back with a verdict of guilty on that aggravated assault deadly weapon, because this should not be okay. San Antonio or Bexar County, or for that matter, anywhere in the world, this is not okay to do to people. What this man did that day on March 16th, 2023. Thank you, ladies and gentlemen.
We're gonna move the TV, Judge.
A 5-minute warning.
Yes.
I have it. I have it.
Oh, you have it.
I saw my bracelet. You had to speak. Oh, no, I keep.
Oh, yeah, this is it.
Okay, yeah.
Thank you. May proceed.
May it please the court, opposing counsel, members of the jury, I am not asking you to like Edgar Aguilar. I am asking you to find him not guilty for what he is charged with and what he's on trial for. Those are two very different things. I am not saying that what he did was okay. Mr. Garahan was saying that if you find him not guilty, you're condoning his behavior or saying it's okay. No, no, no. What's not okay is to bring the wrong charge. If you bring the right charge, we may not be here today. He has been charged with aggravated assault with a deadly weapon. And as I told y'all back in jury selection, the state is the one that has the burden to prove each and every element to you beyond a reasonable doubt, the elements that they have charged him with, the manner and means that they have charged him with. Some of these are not in question. The ones that are in question, I've highlighted in yellow for you here. On or about the 16th day of March, 2023, that's not in dispute. That it happened within Bexar County, Texas. You've heard testimony that it was on near 410 and Vance Jackson where this incident occurred. You've seen maps of where it occurred. We're not contesting that that's within Bexar County, Texas. That it was Edgar Aguilar that was involved in this incident. This is not a situation where it's saying you got the wrong guy. It wasn't our client. It was someone else. No, no, it was him. He's the one involved. Several people identified him. We're not questioning that he was involved in what happened that day. But did he use or exhibit a deadly weapon, namely a motor vehicle? He exhibited a motor vehicle, but he didn't use it as a deadly weapon. Obviously, a motor vehicle can be a deadly weapon. If you run it at someone who's standing on the road, if you run over someone, if one of those women had been outside of the expedition, he could have pinned them between the two cars. That would have been a deadly weapon. But the way he used it, it was not used as a deadly weapon in that course of conduct, in that video. You have the video in front of you. And I'm so thankful that that woman's daughter was able to film. Because if you just hear a truck is ramming into an expedition, well, that sounds really scary. But then when you see it on video, you see the rate of speed, you see the confined space. He wasn't even capable of generating enough speed to use it as a deadly weapon. That he did it intentionally or knowingly, that's up to you to decide his mental state. There's been testimony that he was incohesive, he wasn't making sense, he was saying things that didn't make sense. The whole situation is extremely bizarre. This makes no sense. These women didn't know him. His behavior doesn't make sense. It's very senseless, it's very bizarre, it's very strange. So who knows if you did it intentionally or knowingly? That's sort of up in the air as well. Threatened bodily injury. Well, did he threaten bodily injury? They obviously didn't have bodily injury. There's no testimony that anyone was physically injured, and they all said that. He's actually the only one who left the situation with an injury. But did he threaten it by driving his motor vehicle at the vehicle that was occupied by the complainants? So that's very important too, the manner and means. Because if you think, well, he was threatening bodily injury to Raquel when he's pushing the driver window down. Well, that's not how they've charged it. That's not the manner and means you're considering. So if you think, well, yeah, he did when he was at the window, that doesn't matter. It has to be by driving the vehicle. If you think, well, he did threaten him when he threw this tire iron that you have in evidence at the back of the window, he was threatening him with bodily injury then. Doesn't matter. That's not the manner and means that they've charged him with. And then again, for the example of the deadly weapon, remember John, when my partner, Mr. Kuntz, he was questioning the last witness, the investigator, the detective. And he gave the example of the baseball bat. He said, a baseball bat can be a deadly weapon if you swing it at somebody's head. But if you're just poking someone with that exact same object, then it's not a deadly weapon. So again, we're not arguing that a vehicle cannot be a deadly weapon. It can, but it has to be used as one. And you have the video, and I argue that those three backing up and hitting the expedition, it was not capable of causing death or serious bodily injury to Raquel and Fatima and Brittany. If you agree with me that he didn't use his vehicle as a deadly weapon, the court has actually included in the charge an alternative option for you. They have included in there after each count that if you find there was no deadly weapon, if you don't find him guilty of aggravated assault, there's this other option. If you don't find him guilty of aggravated assault and you agree with me on the whole motor vehicle thing, but you still feel like you need to find him guilty of something, there is this option of assault for each count, for Raquel and for each of her daughters. And the elements of that offense are similar to the aggravated assault with the deadly weapon, but they take out using the deadly weapon. So it's still on or about the same day in Bexar County, Texas, Edgar Aguilar, the mental state is still there, intentionally knowingly threatened bodily injury by driving his vehicle at the vehicle occupied by the complainants. But it takes out that he used a deadly weapon that was capable of death or serious bodily injury to those women. So here I've come up with a short list of other possible offenses that they could have charged him with, but they didn't. And I point this out because I want to make it very clear to y'all that I am not condoning what happened that day. I'm not saying he did nothing wrong. I'm not even saying he didn't do anything criminal. I'm just saying he didn't do the offense that's in the indictment. He might have been driving while intoxicated. You saw him driving the truck. You saw that there were 2 empty Dos Equis and 4 that were not drank yet. There was some sort of pipe of some sort in his pocket. They didn't test his blood. They didn't check if he was intoxicated. He was obviously driving. Maybe it was a driving while intoxicated. Public intoxication. There was testimony that he was saying things about attempting to kidnap a girl. It's possibly an attempted kidnapping. Damaged their vehicle by driving it. Damaged the vehicle by throwing the metal iron. That's criminal mischief. He damaged their property. He's not charged with that. Evading arrest. You saw him run from Captain Wagner and Corporal Lawler. You saw him resist arrest. It took 3 Castle Hills PD to get his arms behind his back and get him detained. That's resisting arrest. He's not charged with that. Open container. There's open Dos Equis on his floorboard when Officer Lawler searched his truck. Possession of drug paraphernalia. There's a pipe of some sort in his pocket. Those are not what he's charged with. Again, I'm not saying he didn't do anything wrong. I'm not saying he didn't commit a crime. I'm not saying he didn't do anything unlawful. Just not the one that he's on trial for. Again, I want to make it abundantly clear that we are not discounting the victim's fear. I'm not discounting what happened to those women. Raquel Ildefonso, the mother of those 2 young girls, when she sat up here, she was super shaken up. She was scared. I'm a mother. I cannot imagine if that would have happened to me with my children in the car, or if that were my mother with me and my sister when we were teenagers. But I want to point out to you that she was most shaken up about when he was asking, give me the girl in the back, give me the girl in the back. She actually sort of calmed down when she was talking about the vehicle being driven into her vehicle. They were shaken up by the whole situation, but not necessarily solely because of the vehicle part. Same with the girls, with Fatima and Brittany. They both said to you during my questioning that they were most scared and shaken up about the comment about the kidnapping. If they didn't know who this guy was, pushing the window down, all this other conduct that's not driving the vehicle, their vehicle. And it's on the 911 call. The conduct that is charged, if you recall, and you'll have the 911 call back in the jury room, and I urge you to re-listen to it. It's horrible and it's scary, and they were scared. But Brittany Camacho, the youngest daughter who was in the back seat, she initially makes the 911 call. And this is when he's out the window, pushing the window down and making the comments about the kidnapping or give me the girl and all that kind of stuff. Then she is so shaken up by
5
that.
minutes.
Thank you. By that part of the situation, that she has to hand the phone to her sister in the front seat, to Fatima. While Fatima is on the phone is when the truck is driven into their vehicle. So they're already shaken up by his other conduct that he's not on trial for. Again, I don't blame you if you hate Edgar. I don't blame you if you hate what he did. We don't blame you if you hate that those women had to go through that. We are not trying to excuse his terrible behavior on March 16th of 2023. But you should blame the system for bringing the wrong charges. If you need someone to blame, blame the system for bringing the wrong charges. We might not be in a jury trial if this were not the conduct that was charged. So here's some final takeaways because I'm running out of time. We're not denying that Edgar's conduct on March 16th, 2023 was egregious. We're not denying that Raquel, Fatima, and Brittany were victims of a crime. We are saying that they were not victims of the crime that the district attorney's office has charged him with and that he's on trial for here today. He did not use his vehicle as a deadly weapon, and you have the video and you'll be able to decide for yourself. You'll be able to gauge how fast that speed was, if he was capable of causing death or serious bodily injury to those women. Therefore, this is not an aggravated assault with a deadly weapon. Therefore, he is not guilty for what he is charged with. Thank you.
All right, state.
Judge, if I may have a mouse in a minute.
Yes. I think something happened with this.
He's hitting our car here. He doesn't want to leave us alone. Please, can y'all hurry up? You heard Fatima Camacho utter these words to the 911 operator when she made her 911 call on March 16th of 2023. Now, I want to talk to you about the elements. We've talked about this. Ms. Enriquez just addressed them. If you look up at the PowerPoint here, I have 2 elements highlighted. I didn't think that they were going to be contesting the mental state, but we'll address that in a little bit. But really what is contested, all of these elements are conceded to, except for the threatening imminent bodily injury to the victims and that the deadly weapon, the motor vehicle, was in the manner of its use and intended use capable of causing death or SBI. So let's talk about the mental state. We've talked about this before. The law does not require you to be a mind reader, right? You're allowed to infer the mental state from words, actions, and circumstances on the offense state. So let's talk about that. Intentionally is defined as what is the defendant's conscious objective or desire. This defendant intended and meant to do what he did on that day. That's not in contest. There's much evidence to support that. Let's talk about how he reversed his truck not one time, not two times, not three times, but 4 times, and intentionally collided with that black Ford Expedition. The first time that he places his truck in reverse, he repositions it to the front tire near the driver's seat. And initially, he doesn't collide, but that's not good enough for him. He has to reposition and make contact. At that time, you can hear on the video that he is accelerating his engine at that time. You can see the tires spinning and you can see the smoke coming out from that truck. That is intentional conduct. He then reverses again and collides with the driver's side door. He reverses again and collides with the driver's side rear passenger door where Brittany was sitting. And at that time, on that third collision, you can see that black Ford Expedition shaking back and forth. You tell me, if they're contesting that Dodge Ram was not capable of causing death or SBI that day, you tell me what would happen if that vehicle the Ford Expedition would have flipped over. Do you guys not think that the victims would have sustained at least a head laceration or something like that? They could have been seriously injured had that car rolled over on that day. And then he reverses again. And on the 4th collision, I will concede. I agree with them on the 4th collision. That was a light tapping. That 4th collision was not an ag assault with a deadly weapon, but those 3 before were. And then that's still not good enough for him. He still gets off of his motor vehicle, goes into his toolbox, gets a metal rod, and splashes and shatters that back windshield. Now let's talk about the testimony. You heard from multiple witnesses that testified in this case. First, you heard from Vanessa Fernandez. She described an emotion that she observed on that date as ramming. She did say that they were in a confined space. However, you all saw the video. He was able to reverse and he was able to accelerate. And she testified to that. She testified to the tire screeching and the smoke. And she testified that her perception of this defendant's actions on that date were that they were intentional. And she was worried about the safety of herself, of her daughter, and of the occupants of the Ford Expedition. Deputy Garcia testified that he observed frantic motion within the Ford when he first encountered them on Fredericksburg Road, and that when he made contact with them, they were panicked, scared, and crying. And you all saw that yourselves. Now, Raquel testified that she first noticed the defendant on Wiseman Boulevard. And she testified that the ramming that we saw in that video was not the only ramming that occurred on that date, okay? The defendant was ramming her vehicle well before her vehicle became stationary at 410 and Callahan. That is another fact that proves.
I'm gonna object to mischaracterization of the evidence.
All right, ladies and gentlemen, you will remember the evidence as you received it.
That is the evidence, that is additional evidence that proves the intentional actions of the defendant. And she testified that initially, when he was initially ramming the vehicle before 410 and Callahan, she did
No,
not
I'm gonna object to
initially.
mischaracterization of the evidence. She never said that it was rammed before they were stationary.
All right, ladies and gentlemen, you'll remember the evidence as you've heard it.
She testified that initially she did not perceive the ramming as a threat. However, that changed after the defendant approached the driver's side vehicle and then the driver's side of the Ford and then re-entered his Dodge Ram and intentionally struck her vehicle 4 more times. Now, Brittany Camacho testified that she first noticed the
5
truck
minutes.
when she was at home throwing the trash away. And I will concede that she was very shaken up and she was placed in fear well before the vehicle was rammed. And that's why she had to get a fishing pole, because she felt that she had to defend herself and her mom. And Fatima, you guys listened to that 911 call. It tells you everything that you need to know. Specifically, when she mentions that the car is being rammed, she's screaming. And investigator Martinez testified to you all that he believed that the defendant was using his motor vehicle as a deadly weapon on the date of the offense. He believed that the defendant acted intentionally, and he believed that the defendant intended to threaten imminent bodily injury. Now, defense wants you to believe that the victims were scared before the ramming, that they were placed in fear by the defendant trying to commit an attempted kidnapping, and that they were placed in fear by the defendant shattering the back window. So I pose a question to you all. What was the scariest part of that day? It doesn't matter, because in that jury charge, it doesn't say that the victims had to actually be threatened. It is focused on the intent of that man sitting right there. What was he trying to convey to the victims when he was engaging in that conduct that day? And we're going to look at the totality of the circumstances. We cannot just piecemeal and say, oh, one part was scary. Look at it all together. The pulling down of the window, demanding Brittany Camacho, ramming the Ford Expedition, and shattering the back window. His intent was to terrorize the victims on that day, and he did. And their fear was exacerbated over and over and over again. You're the judges, exclusive judges of the facts and the credibility of the witnesses. You saw them today or yesterday when they testified. You saw how shaken up they still are coming into court and testifying against this defendant. At this time, you're only deciding guilt or innocence and nothing else. Did he commit the acts in the indictment? I submit to you, yes, he did. Not defenses to this offense. The victims didn't drive off fast enough. There were no barriers to the car. There were no cars in front of the victim's car. The defendant wasn't driving at a high rate of speed. The victims didn't have physical injuries, and both of the vehicle doors were open and there was limited damage. Those are not defenses, and you do not consider that in the deliberations. In jury selection, you all agreed that an ag assault could be committed even if the victims did not sustain bodily injury. You all agreed to that, and that is the oath that you are sworn to take today. Now, you've been instructed that you cannot let sympathy play into your deliberations, okay? And so if you're feeling like he needs help, he doesn't deserve jail time, you feel sorry for him, or he has mental health or substance abuse issues, those are not for you to consider at this time. The judge is going to decide punishment, and she can take them into account at that time. They are not relevant in your deliberations. You all swore that you would render a true verdict according to the law and the evidence. And there's only one verdict in this case. Now, I want to address a couple of things that Ms. Enriquez said.
1 minute.
Just because the court did give you the option to find on that lesser included misdemeanor offense, it is not the court commenting on the weight of the evidence or indicating to you anything that you should do. Aggravated assault was the most appropriate charge, and that is why that is what he was charged with in the indictment. He threatened three others with imminent bodily injury, and he used or exhibited a deadly weapon during that. That is a deadly weapon. You see right there, it says it's a heavy duty truck. He has all of that equipment, and he even caused damage to his own vehicle due to his actions on that day. The lesser included misdemeanor offense is inappropriate because we all talked about in jury selection that a motor vehicle could be a deadly weapon. And on that day, that Dodge Ram 2500 was able to cause death or serious bodily injury. It doesn't have to, it just has to be able to.
Time.
And it was. Find him guilty.
All right, ladies and gentlemen, you've heard all of the evidence that you're going to hear in this case. I said that you might drop that thing. All right, thank you.
Thank you.
Oh, please be seated, everyone.
The map outside.
All right, ladies and gentlemen, Deputy
Bye-bye. All right, thanks, Mom. Okay. Is it keep that on?
Yeah.
Guys, I'm gonna go back to the office.
Yes.
Somebody will be on standby in case there's a question, a verdict, or whatever.
All right, thank you.
Thank you, Judge.
Have a good one.
You too.
Approach very briefly.
Sure.
We've got that really difficult Patrick, that McKinney guy that we're set for back-to-back titles. Hey, we're Scott. Tuesday or yesterday. And it's you need a case number, I don't know. Case number, okay. They're okay with it.
All right, so if you'll talk to Ms. Ferguson
Okay.
and then have them bring the files out to me so I can put it in the system. You're welcome.
Okay, thank you.
Hello. Happy Valentine's Day. I almost wore all black. We are. Well, I wasn't thinking of Valentine. I was just like, the black goes with this. Oh, I'm doing good. I cannot complain. And
Well,
Apple movie.
it won't be cheap, you know that.
Oh, yes.
Where are you going?
To help break up my daughter got into PA school. She lives in New York, but she's gonna move down to, I don't know, down to southern, down by Wall Street.
Oh, in Manhattan, my bad.
All right. Mr. Diaz,
Mr. Diaz?
yeah, come down.
Bedroom.
Hi. So, you were not here. Where were you? You were supposed to be here yesterday. All right. All right, so here's the thing. When you're on the docket, you need to make sure you show up. Otherwise, a warrant could be issued for your arrest. Do you understand? Which it has been. And counsel, you're on the bond?
Yes, I am, Your Honor.
All right. State, do you have any objection to recalling the warrant?
No, Your
Okay.
Honor.
All right. And where are we on discovery?
Your Honor, I need to make sure that we have it all. I think this is our first setting since we got hired. So I need to do my due diligence.
All right. So I'm going to recall the warrant and ask that the bond be reinstated. You're the bondsman. Do you have any
I have
objection?
no objection, Your Honor.
All right. And we're going to recall this for March 20th.
Your Honor, could we do the 18th? Week?
Yes.
Okay, thank you, Judge.
All right. And if you'll let Ms. Ferguson know so she can give you a reset form.
Okay, I'll have him sign it.
Yes.
Okay.
All right.
Thank you, Judge.
On this one, the warrant is being recalled.
Take a moment. You had a ticket, but. That was a class A, I mean, a class C ticket. I'm not sure because I don't work in that area, but. Pretty much. You've been. Yeah. Yeah. You're good. Gonna get a reset on?
Yes, he is. He went back to have the coordinator do it.
Okay.
Oh, I thought you said you didn't want a jury trial, you wanted to take it to here. Do you want a jury trial? Well, that would be today. I gave you had 3 options, both want a jury trial.
Oh, did you need something?
Yes, Judge.
Yes.
And the third one.
Hello. So both sides have done their closing arguments, and I'm gonna give you a printout so you can see what a jury charge looks like. Let me go here.
I have a question about the charges.
Yes,
So when bringing charges to, the defendant, is it under the discretion of the prosecutor that's assigned or the DA's office to like bring charges?
it really depends on how the district attorney runs his or her office.
Mhm.
When I was in the office, and it's probably still the same way now, what ends up happening is the police will bring a case to the district attorney's office. And then the district attorney's office and the police officer may say, we believe this is a murder. We believe this is an aggravated robbery. But the attorney, who's an attorney in the prosecutor's office, may look at it and say, no, this is incorrect. This is not the correct charge. The actual charge should be something else. So the prosecutor who has the case will usually make that determination, whoever is going to be the one who's indicting the case. So that's the way it usually works. But let me give you a copy of the chart so you can see what it looks like. You're welcome. I will tell you the criminal side and the civil side are completely different. On the civil side, the persons who usually prepare the jury charge are the attorneys. So sometimes it's the plaintiff's attorney, sometimes it's not. And they'll agree on what they think should be in the charge, and then ultimately the judge makes the decision. Here on the criminal side, we have staff attorneys, and those attorneys they have a standard set charge. On the civil side, the reason why they don't have standard charges necessarily is because there's so many different types of civil cases. On the criminal side, what's in the penal code are what are offenses that you can be charged with. So you'll have a set charge for a murder case, for example, or for an aggravated robbery. And then what they'll do is they'll add certain things if parties want certain things. Sometimes you have a set murder charge, but maybe somebody is going to allege self-defense. So then we'll let the staff attorneys know, and the judge will make a decision whether or not there's enough evidence to have a self-defense charge in the jury charge. And we'll call the staff attorney and say, we need a self-defense added to the charge, and then they'll put it in. And then they will send a charge to the court, and I will give the charges to the defense and the state to review overnight. And then they come back and they'll let me know if there's something they want added to the charge or something they want removed from the charge. And we have an argument about that, and they'll present me with their case law or why it should be in there and why it should not. And then I'll make a ruling. And yes, and then if I'm incorrect in my ruling, or they think I'm incorrect in my ruling, the defense attorney will appeal it. And then the fourth court or whichever appellate court it ends up going to will make a decision on whether or not my ruling was correct or not. Yeah.
Because I was just wondering, because there's open files of those keys and then, why not bring forward charges of, drunk driving and then he was also found the.
I just tell you, you have the two prosecutors right there who will talk to you about that. Yeah, so ask them. All right, everyone, this is a student from my class. He wants to talk to you about this case and the charges. Yes.
Megan, nice to meet you.
I was just wondering.
Go take a seat right there.
Just wondering what your charge is. It's not also. That was unbelievable.
I'm pretty in charge of the walkthrough.
Was this the case?
The way that our office is structured.
No.
Oh, okay.
Oh,
okay.
And they, when the cases are turned over, they're the ones
Thank
that
you.
review it,
Okay.
and
So remember.
indictment, which is the charging
Oh.
and present it to the grand jury. So I can't see for why that person does it that way, but I know like if I would have been like that, I would have stepped down.
This is for the 108 days.
That's the appropriate term, but they would have included an additional.
Left or charge.
And then.
It's like one step above the next. Okay, so this
document is telling you that the rank, if you plead guilty and no contest, or plead jail felony, the punishment is from 100. No. And the deal is 180 minimum. Okay? You're not, the judge has several options available to her, but she's gonna have. Right, so all these are for probation. Don't worry about it. I'm not. Would you consider probation?
Well, he's gone to state jail like 2 times already.
He's gone to state jail 2 times already.
Yeah, I mean, yeah, if he wants probation, 2 over 2, state jail.
2 over 2. So you could be on probation for 2 years.
Oh, just
Facing 2 years.
But you'll find this funny, Judge, my old first chair,
Mhm.
he's no longer in the office, he's in Kendall County, but I'm saying it. Oh, it's Megan and the bald guy.
Okay, I'm telling you. Yeah, it's a perfect match. If we were to do the set, you remember on Sesame Street, they would do this, one of these things are not like the other. We would just be,
Put two together, you circle the part that are.
but it's so funny. Now I remember all of the songs for Sesame Street. And then I remember one where this lady had the zipper and she was having a problem with it. And you learn who invented the zipper because she's like, who invented the zipper? I want to talk to him now. It's just out there. All right, Ezekiel Martinez. Yes. Oh, where's the court reporter?
Oh, yeah, we need a
Thank you. I'm like, I could write it down, but. Hello, how are you doing?
Fine.
All right. All right, so we're just going to wait for the court reporter to come out and then we'll start. Richard, how are you doing this morning?
Running around, hungry, starving.
I mean, are you really starving?
I am beyond starving.
No, I don't think so.
Ethiopia starving.
No. The court is calling 2024 CR 012265 State versus Ezekiel Martinez. Can I have parties announced for the record for the state? Defense.
Richard Garcia for the defense, ready, Your Honor.
And are you Ezekiel Martinez?
No.
Counsel, have you received all discovery and did you review it with your client?
We did, Your Honor.
The court will find that the state is in compliance with discovery. Just one moment, I'm sorry. Mr. Martinez, did you review the true bill of indictment with your attorney? Did you understand it?
Yeah.
Yeah, it's this document. It tells you what you're charged with. Did you review that with your attorney?
Yeah, I think something like this. Yeah.
Well, I mean, I don't want to say have you to think so. So the indictment tells you what you're charged with. Do you know what you're charged with?
Yeah.
All right. Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Not the, well, it's an enhancement in the elements, but then below that line, the state's enhancement paragraphs are being waived. So
That-
they're being a state jail.
That's correct, Judge. We have no objections to that.
Oh, yeah, and I wanted to know if I could get one of the papers so I could say the officer was saying that I was doing.
Just listen to the questions.
Okay. All right. So did you review the court admonishments with your attorney? The court admonishments tells you what your legal rights are. It's this document. Did you review that?
Yeah.
All right. So what you're charged with is evading arrest or detention with a prior. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Do you understand that's the range of punishment?
Yeah.
All right. If you have a plea bargain agreement with the state, I don't have to follow your plea. If I don't follow the agreement you reach with your attorney and give you more than you bargained for, the fact that you entered a plea, it will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yeah.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering into this plea bargain agreement, you are giving up those rights. Did you understand?
Yeah.
And did you intend to give up those rights to enter into this plea bargain agreement?
Yeah.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea bargain agreement that you've reached?
No.
Are you satisfied with the way you've been represented?
No.
Right.
Because I thought it was a ticket. I don't know.
All right, I'm going to explain something to you, and then you can let me know whether or not you wish to continue with this plea bargain agreement, because if you would like a jury trial, the court will give you a jury trial. So evading arrest detention, that means, we can go off the record. In layman's term, that means if a police officer is trying to stop you lawfully and you take off running, that's evading.
I know.
Now, if you've evaded more than once, they get to bump it up to another level. Now, whether or not people believe that running from a police officer should be a felony or not, that's not in my purview. My whole goal is just to follow the law.
Okay, I'll take this. Yeah, I'll take.
No. My question to you is, are you satisfied with the way you've been represented?
Yeah.
If, I'm sorry?
Yes,
All right. Are you a U.S. citizen?
yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney?
yeah,
Do you understand it?
yeah,
According to the plea bargain agreement, punishments be assessed at 180 days in the state jail facility, and there are no applications. Did you understand that to be the plea?
yeah,
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and did you sign it?
yeah.
Did you understand
Yeah.
that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yeah.
Counsel, are there any such motions?
No, Your Honor, there have.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Contest.
State, any evidence?
Yes, Your Honor.
No objections, Your Honor.
All right. Did you review the waivers and stipulations with your attorney? It's the document that shows you what evidence the state says they have against you. Did you review that document?
Yeah,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
yeah,
All right, did you understand that today the state would not be calling any witnesses? They're going to be presenting evidence in the form of police reports and judgments. Did you understand?
yeah,
Okay. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, we're asking that you waive the pre-sentencing investigation and sentencing.
Is there anything you wish to say on behalf of your client?
Your Honor, we're just asking that you follow the plea bargain. That, I guess that's all I have to say.
All right. The court will find you guilty. The court is going to sentence you to 180 days in the state jail facility. The court will give you credit for any time that you've already been in custody, and the court will recommend the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
okay,
Did you review that?
yes,
Did you understand it and sign it?
yeah,
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. All right, we can go off the record. Good luck to you, sir.
thank you.
You're welcome.
Thank you, Judge. So here's my